Good morning, everybody. Good morning. We had finished separation of powers, judicial review, and activism in our last class, and I thought that while we are in the mood for a little bit of judiciary, let's finish up the judicial theme first, and then we'll come back to center-state relations in a day or so. Right? Good morning. Good morning. So we'll just change the order of the themes a little bit. And instead of starting with center-state relations, we'll start with judiciary first. So we are now rearranging and we're going to do theme number 6, which is judiciary and the judicial system. Let's keep in mind that tribunals as a topic of separation of powers, judicial review, judicial activism, as again extensions of separation of powers, right? All of these topics have been already covered, so we will not do them again here because they were largely issues of separation of powers. Now, how do we essentially tackle this topic as far as our exam is concerned? We will of course do layer 1, which is conceptual and factual in nature and therefore refers to the prelims. Then we will do layer 2, which is analytical in nature and therefore refers to the mains. Okay? All right. Now every OBC certificate has a validity. याश तो एक बार आपकी certificate पे validity देख लो. We are changing the theme, so we'll do this as theme number 6. That's what I said. Okay. Theme 1 basic concepts, theme 2 fundamental rights, theme 3 parliament, theme 4 theme 4 parliament, theme 5 theme 4 president, theme 5 parliament, now theme 6 judiciary. Okay, now chaliye, we'll first understand with the layout and the structure of the judicial system. That's very important. Once we are done with this, we will then get into specific issues of appointment and removal. Third, we will understand jurisdiction. Then we will understand some additional powers such as a court of record and contempt. Now, these are the 4 basic explanations that are more than enough as far as our pre is concerned. After we are of course done with these, I'll supplement these with some previous year questions so that it's easy for you to see that your preparation is on track. Once we are done with this, then we're going to do layer 2. From layer 2, we'll extend appointment and removal, and we will understand reforms to appointment and removal. Second, we will look at all India judicial services. Third, we will look at women in higher judiciary. Women in higher judiciary. Once we are done with this, we will then understand the contempt issues in analysis as far as the courts are concerned. And finally, from a larger theoretical point of view, we will understand what is truly meant by the independence of judiciary. Okay? And then we'll supplement it. See, as far as judiciary related questions in the mains are concerned, you either have issues of the judiciary with other organs of the government, such as tribunal review and activism, or you have issues just about the judiciary, which is usually about pendency and all of those things. So when we study pendency and case workload and all of those things, you'll be able to do them in the larger structure of reforms. The data here needs to be updated before your mains exam, a month before your mains exam in 2022. So I'll tell you how to update the data, and I'll also update the data for you. Okay, so this is the larger structure as far as judiciary and the judicial system is concerned. Now that we are okay with this, now that we understand this, we'll of course through this also look at should there be reservation for women in judiciary as a whole or not, and we'll get to those when the time is right. Okay, now let's first spend some time on the judicial structure, or on the structure of the judiciary in the country. Let's understand exactly what it is that we are referring to. Now, when we are referring to the structure or the layout of the judiciary or the judicial system in the country, we must understand that there are broadly two important players involved. There are broadly two important players involved. One, of course, are your courts, and the second, of course, are your lawyers. I'll give you broad explanations to all so that it's easy for you. Okay? Now, we'll do a top to bottom approach. As far as the courts are concerned, we use two I's to explain the system, wherein we say A, it is independent, and B, it is integrated. A, it is independent, and B, it is integrated. Now, how are they independent and why are they independent, and how are they integrated and why are they integrated? We'll come to that in just a few minutes. So let us start. When we look at the structure of the judiciary per se as a whole, what do we understand? There is the Supreme Court at the top. The Supreme Court is the apex court of the country, or is the highest court of the country. Okay. Now, the Supreme Court, under it has high courts. High courts are the highest courts of the state or the or the union territory. There can be a single high court for multiple states also. Now, collectively, the Supreme Court and the High Court are called the higher judiciary. Okay. Now, below the high courts are district courts. Then below district courts are lower courts, such as civil courts and criminal courts at the district level or below the district level. And then you have the lowest court, which is the Gram Nyayalaya. This is the lowest court. Now, right from the Gram Nyayalaya to your lower courts, where you have civil courts and criminal courts, up, you go up to the district court, the high court, and of course, the Supreme Court. Now, this ecosystem is also called the formal or the institutional ecosystem. Now, a lot of times we start creating specialized courts. These specialized courts are, like for example, at the level of the district, you can have a family court. You can have a family court. Okay. Now, this means appeals from the family court will go to the high court, and appeals from the district court will also go to the high court, and appeals from the high court eventually go to the Supreme Court, right? So these are your formal institutional mechanisms. Then you have, at the parallel level of the high courts, you have tribunals, which we have discussed before, wherein tribunals have members of both the judiciary and the executive, whereas here only judiciary, here only judiciary, here only judiciary, here only judiciary, and here only judiciary. Now, members of the tribunals are collective in nature, and that is why it becomes a larger issue of separation of powers. And tribunal cases on a case-to-case basis can sometimes go to the High Court or sometimes go to the Supreme Court. And this is still often also called your formal or your institutional legal system. Now, what if you don't want to go to court, right? What if you don't want to go to court? You want to settle the matter outside court, but at the end of the day, it is still a legal dispute. Then we have a system called ADR. ADR, which we will study today, alternate dispute resolution. Basically, out of court settlements. Alternate dispute resolution. Now, there are several forms of this. For example, you have arbitration, you have mediation, you have reconciliation, and sometimes people also call it negotiation, right? These are basically not a formal ecosystem. This is essentially a parallel ecosystem that you don't want to go to court, and two companies or two individuals can sit and sort this out. Now, you can also have, like how you have a family court specialized only for family cases like divorces, etc. You can also have courts at a lower level which are specific in terms of a time limit. So nowadays we also have parallelly fast track courts. Fast track courts, FTCs. We've usually looked to set them up for corruption cases or serious cases against women and so on and so forth. But this is broadly the structure of the judicial system in the country. Okay. Now your tribunals are placed here, your family courts, fast track courts are placed here, and this is how it is done. Now, the difference is Supreme Court and High Court appointments, right, or removals. This entire process is through a collegium and their process is nationalized. As far as district courts are concerned, or judges of the district courts are concerned, right, this is done state-wise, where the written exam is conducted by the government and the interview is taken by High Court judges. This is often called your PCSJ exams. And there is a proposal for the last so many years to have a national entrance exam for recruitment to lower judges. And this is called an All India Judicial Services. A national entrance exam to recruit judges at the lower level. Okay, not Supreme Court or High Court, because this is done through a collegium process and separately. Okay, this is a judicial service. This is the judiciary. So there is going to be some difference. They tried reforming it a while ago through the 99th constitutional amendment, which is called the National Judicial Appointments Commission. But that was, of course, struck down by the Supreme Court as a violation of independence of judiciary. Now, this is broadly how the ecosystem works. Now, let's get into the technicalities of this. First is the word seat, where we say the seat of the court. Where is the court? Right? So high courts will be there in a state, district courts will be in a district, lower courts will be, in a subdivision or block. Now, as far as the seat of the Supreme Court is concerned, first things first, while we understand that there is a Supreme Court in Delhi, but it does not mean that the Supreme Court necessarily has to be in Delhi. Okay. How a court basically requires a judge, the lawyers, and the people involved in the case, and that's a court, right? It doesn't have to necessarily be in a building called the Supreme Court of India. In fact, so many times in our careers, for emergency cases, for emergency appeals, for emergency hearings, we have argued at the residence of the judge with both the side lawyers also there, because all you need for a court is a judge and the lawyers, the people involved, and probably a steno to make a record of things. So there is no compulsion that the court has to be in that designated physical capacity. It can be anywhere, right? So that's the first part. The second part is, we often use a word called bench. Now, bench means two things. First, the number of judges inside one courtroom, the number of judges in a courtroom. Suppose, we have, say, the Supreme Court, let us say, has 10 courtrooms or 30, 15 courtrooms. Then how many judges are in each courtroom? That is what is called a bench. So a single judge bench, a double judge bench, like that. Okay. Now what we know is, if the court is hearing a matter which requires the court to examine the validity of a law, in that scenario you require a constitution bench, and you require minimum 5 judges to be a part of the constitution bench. Okay, so that is of course what is called the first meaning of bench. The second is the number of branches. The number of branches of a court, which means, for example, UP has 2 high courts. The principal bench of the UP High Court is actually called the High Court of Allahabad, and then you have an additional bench in Lucknow, right? So for example, UP has 2 high courts. The main high court is in Allahabad, and the secondary high court is actually in Lucknow for greater acceptance and processing of cases. Okay, so this is how your seat and benches work. Now, after this, we will of course get reforms to seats and benches later on. That does the Supreme Court necessarily have to be in Delhi? Can we have an appellate court system? How are benches decided? We'll come to that. That is okay. But you should understand the terms. That, for example, when I said a 7-judge bench decided in the case of ordinances a 3-layer test. So a 7-judge bench of the Supreme Court. Okay, so that is what is meant by a bench. There are 2 meanings. 1, the number of judges in a courtroom, and 2, the branches of a court. The number of judges in a courtroom, and 2, the branches of a court. Okay, now once you're okay with this, once we understand this, once we're fine with this, then we look at certain words. First is, we often understand there's a word called court of record. Now a court of record basically means 2 things. I mean, it's not going to be particularly asked in the exam, but what is a court of record? A court of record means 2 things. First, that anything presented before a court, any document presented before a court, any statement given before a court is a final statement. You can't mislead the court. You can't submit false evidences to court, false statements to court. It is a matter of record that if you've gone and submitted an affidavit in court saying that my name is A, but your name is actually B, you can't lie in that document. That's the first meaning of court of record. The second meaning of court of record is that because everything is placed on record at the court can review its prior judgments and will often be bound by its prior judgments. So unless, like for example, if a 5-judge bench of the Supreme Court has decided X, then until you have a 5 or more judge bench, the 5-judge bench of the Supreme Court's decision will be applicable subsequently. Okay, you cannot revise it with a lower bench. You are bound by the directions of the lower court. Okay, so this is what is called a court of record. Then we also have something called court of contempt or contempt of court. Now Supreme Court has its own contempt powers, and High Court not only looks at contempt of the High Court but also of all lower courts as well. All lower courts as well, right? So in that way, the High Court has broader contempt powers. It is the guardian of not only itself but also of all the lower courts within the territory of the state or the union territory, or a combination of 2 in case there is a joint High Court, right? A contempt of court is something we had broadly understood under Article 19. It is in the constitution but is also regulated by a dedicated special law. It's called the Contempt of Courts Act of 1971. And there are two kinds of contempt of court. One is civil and the other is criminal. So if you say something which scandalizes the reputation of the court or the judge, then it is contempt of court criminal. And if you don't follow the order of the court, then it is called contempt of court civil. Okay? Or civil contempt of court. So these are the broad terms. This is the broad ecosystem that the judiciary largely operates under. Okay. Now that we are sort of okay with this, we understand this. Let's get to the lawyer's bit. Okay. I'll give you some time to sort of get this right. Now, first things first. Who is a lawyer? Who is an advocate? Who is an advocate on record? And who is a senior advocate? Now you see, the courts and the lawyers, right, the judges and the lawyers have a midpoint of sorts. They have a meeting point. And here you have your bar associations. Okay. So you've got the Supreme Court Bar Association and you've got the respective High Court Bar Association. Right? Now, see how this works. A lawyer, advocate, advocate on record, senior advocate, and let us say jurist. What is the difference between the three, all the four, and let's understand what is meant by either of these. So, a lawyer is anyone with a law degree. A lawyer is anyone with a law degree. That's just a person who's a lawyer. Whether they practice law or don't practice law, it does not matter. But anyone with a law degree is a lawyer. 2. Anyone with a law degree who is practicing law or is appearing in court, is arguing in court, okay, is arguing in court, is called an advocate. Now, advocate on record is very interesting. This applies only to the Supreme Court, and there is a written exam for it. You have to have 5 years of law practice minimum to appear for this exam. This exam is subjective in nature, has, procedural law, has important judgments, law and ethics, and so on and so forth. Now, once you become an AOR, by the way, then you are able to file cases in the Supreme Court. Now, please understand, this is, don't miss the boat on this. See, the Supreme Court is the apex and the highest court of the land. So it was thought that the cases that must reach the Supreme Court must be worth the time of the Supreme Court, must be worth the dignity of the Supreme Court. Just because you can go on appeal to the Supreme Court doesn't mean that you end up going to the Supreme Court for extremely trivial cases which do not have complex questions of the law. So it was decided that while anybody can argue at the Supreme Court, any lawyer can argue at the Supreme Court, that is okay. But before you argue, before you file a case, you have to be Aryan, can you just be quiet for some time? Do you think I will not discuss those words? Can you just pay attention and not break the flow of the class? Or else I'll have to throw you out of class. Now, anybody can argue in the Supreme Court, right? But before arguing, you have to first file a case. Now only AORs can file the case, which means that there has to be a signature of the AOR on the petition. So there is every court has a registrar office. We go to the registrar's office with our papers, and suppose I'm filing a case in the Supreme Court, either I will be the AOR or I'll have the case signed by an AOR for me to be taken. Anybody can argue, but only the case has to be filed with primarily the name of the AOR. There can be other lawyers. Okay. Now, the reason this was set up is so that the AORs are well versed with the case and are able to understand as to why we are doing this, are able to understand that, the case deserves the attention of the court. Okay. Now, today what happens is these AORs have just become a procedural formality. Just for signing, they charge 30,000-40,000 rupees, which also adds to the legal cost of going to the Supreme Court. Okay, so there is of course a debate on why do you need to know this, because most of the AORs have no idea what the case is about. It's just a procedural formality which is going on. That's it. Most lawyers are not AORs. Some of the top lawyers that you would know, some of them are no longer alive, say Ram Jethmalani, Jaitley, all of these guys, not AORs. But let's say even say Kapil Sibbal, his son Amit Sibbal, Akhil Sibbal, his another son, Mukul Rothki, his sons, none of them are AORs. You simply hire the services of the AOR. That, boss, I need your signature on this, and we'll carry on. It's like a signature of permission which is required, like an attesting authority, like a gazetting authority. Okay. Now, once we're okay with this, we'll now look at senior advocate. So a senior advocate is something which is designated by the court. It requires you to have X number of years of practice, and then you just wear a different gown. And as a senior advocate, and this, everybody can't use the word senior advocate. Like I can't, because I'm not a designated senior advocate. I'm an advocate, but I'm not a designated senior advocate. A designated senior advocate is a prestigious thing that the court recognizes that you are someone who's seasoned in the field of law, and the court recognizes you to be a fine and a good advocate. And it doesn't really make any difference to your legal practice or your business of law. It's just a recognition which is usually collectively done on the recommendation of the Bar Council and of course the court. Okay, so that is exactly how it is done, right? Now, this is what a senior advocate is. And a senior advocate, therefore, enjoys a degree of status and some kind of reputation and so on and so forth. You may remember Justice Nariman, who retired very recently, Rohinton Nariman, right? He was one of the youngest designated senior advocates of his time. I haven't seen a better lawyer and a better judge than him. And a jurist is anybody who has firm and great knowledge of the law. Okay, firm or great knowledge of the law. You don't have to necessarily be a lawyer for the same. And Lakshmikant is not a jurist. Let me be very clear on this. Lakshmikant is not a jurist. Lakshmikant is a kunji. It's a guidebook. Guidebooks are not jurists. D.D. Basu was a jurist. M.P. Jain is a jurist. M.V. Piley was a jurist. Right? These are your jurists. Okay? But Lakshmikant is not a jurist. So I'll tell you the difference between what a jurist does and what a non-jurist does. Okay. So this is what a non-jurist's book looks like. Okay, this is the Bible. This is absolutely good enough for students for preparing for UPSC or your next IAS polity material. Both are more or less the same. So your next IAS polity material, which is, I think I have a copy here. Okay, these are your non-jurist books. Okay, these are your non-jurist books. They are not jurists by any standards. Now, if you want to know what jurists are, I'll tell you what jurists are. So, for example, when I make your notes on comparative constitutional law, I refer to a book by M.V. Piley. This book comes in 2 volumes, Constitutions of the World, Volume 1, Constitutions of the World, Volume 2. And it is from these 2 books that you get 10 pages of handouts, which are for your means. This is a jurist, okay, who's analyzed constitutions from all over the world. Now, similarly, all of you would have heard of D.D. Basu. Right, or D.D. Basu, this is a shortened version. This is not a full jurist edition or a full exhaustive edition. The full exhaustive edition that we refer to is, I mean, this is where we get a lot of your books, your lectures from, is this. And this is still the shorter Constitution of India. Articles 101 to 151, Volume 1, and 151 to the end is Volume 2. This is the actual D.D. Basu. Okay, right? Similarly, you have something called MP Jain. Now, these guys are not lawyers. Again, these are also what are called jurists. ठीक है, ये constitutional law है. Understood? Okay, not our guidebooks. So, this is largely how it runs. This is largely the ecosystem. Okay, now, as we know that there are some British traditions that we have followed, and I'll give you some British traditions. Okay, let's understand certain British traditions. First is the nomenclature. Okay, the first is nomenclature. So when we say nomenclature, what do we understand? How you address the court. So your lordship, your honor, these are very British traditions. This is that has yes. So these are your nomenclatures. Okay. So for example, your honor, your highness, यहाँ your highness नहीं चलता है. Your honor, your lordship, your ladyship, ऐसे. ठीक है. So this is how it is. 2, the whole system of gowns. So the theory behind this is that lawyers, you'd see they wear very Harry Potterish kind of gowns, right? Judges have a different pattern on their gowns. Lawyers have a different pattern on their gowns. Advocates and designated advocates will have a slightly different pattern on their gowns. Okay, right? Now, let's understand this. Let's understand how this works. So, basically, it is understood that law is supposed to be a noble profession, and I don't think that's the case anymore. But law is supposed to be a noble profession. So the concept of a gown was, right? Okay, the concept of a gown was that the gown, like how I'm wearing a hoodie, right? Like this. So gowns are supposed to have a little bit of a pouch at the back. And the original intention was that once the case is over, the lawyer will face, their back towards the client, and whatever the client feels is good enough a fees for the lawyer, they will put the money just put it in the gown, and the lawyer will not see, close it and go home, because you're a service. You are primarily fighting in the interest of justice to the best. You can't put a price on justice. But if there's anything you can put a price on in India today, that is justice. Okay. Third. You would have heard of these 2 words. One is called a barrister, and the second is called a solicitor. Now, both of these words are no longer actually used in India. They are redundant now. but these are all British traditions. Like for example, you would know Mahatma Gandhi was a barrister at law, right? वो लिखते थे ऐसे bar at law, right? Barrister at law, bar at law ऐसे करके लिखते थे, ठीक है? Now the basic explanation was that in Britain you basically had two kinds of lawyers. In Britain you basically had two kinds of lawyers. One were the lawyers who were practicing in a court. One were the lawyers who were practicing in a court. Okay, if you could argue in a court, you'll have to be a barrister. But if you only wanted to give legal advice, you did not practice in court, you did not appear in court, then you would be a solicitor. And after your law degrees, like for example, UK even today still has this. So UK has only a 3-year LLB program, and this 3 years can be done after class 12th also, equivalent of the UK. After this, you can decide whether you want to be a barrister or a solicitor. Now, if you want to be a barrister, you'll have to go to schools of Inn. Okay, these are barrister schools. Lincoln, Grey School of Inn and all of that. Very interestingly, Gandhi and Jinnah went to the same school of barristership, and in fact I visited it. It's right opposite the Royal Courts of Justice, which is right next to the London School of Economics in London. And if you go to their common hall, on the same table is Gandhi's and Jinnah's statue kept on the table as a sign of notable alumni, right? So this does not happen in India anymore, but this is still a part of barristership. Okay, so this is that. Now, what is another element that does not happen in India is that judges and lawyers don't wear wigs, right? Judges and lawyers don't wear wigs. They used to wear it. The judges still wear it in the UK. Okay. Now, these are your basic British traditions. This is how it is done. Now, of course, if it is a PIL where locus standi is not applicable, then or it's not very strict, then you don't require an AOR to file a PIL as such, right? So this is your broad ecosystem. This is how the lawyers and the judges, they coexist. There's a bar association, which is why you will see a lot of judges addressing the bar association. The bar association will play a strong role in that these are the things that lawyers want. These are the things that should be done. A lot of your names for recommendation for judges are often collectively sent by the bar association, and so on and so forth. Lawyers are regulated by something called the Advocates Act. Now there have been two basic changes. So what used to happen was, and now that's not the case anymore. So after graduating from law college, now at law school, I did not have what is called a law entrance test. Now there is a licentiate law entrance exam, your bar council exam, or your practitioner's license exam. Now nowadays kids who graduate out of law school have to write this All India bar licentiate exam. It's an open book exam. It's not very tough, but still people fail. I don't know why. But that's the first thing. The second is, once you have passed it, you have to register yourself with any High Court Bar Association of the country that you feel like. What used to previously be the case was that you could only practice at the Supreme Court, or you could practice in the courts of the High Court Bar Association that you are registered with. Okay, understood this? Now that's not the case. Like for example, I am registered with the Delhi Bar Council, but I can practice in any High Court of the country. That was not the case 6 years ago, where if I had a case, if I had a client in Delhi and the client's case was in Calcutta, and if I had to go to the Calcutta High Court, I could not argue in the Calcutta High Court. Now I can. The rules have been changed. Okay, so this is how it works. Now, very interesting, extremely interesting. If you are an advocate, right, you cannot be in full-time recruitment or full-time occupation unless you have a specialized permission. Right? So for example, if I was a civil servant, I could have not practiced law. The Supreme Court gave very clear directions about 3-4 years ago, and this was because of the lawyer lobby, that MPs who are not ministers can practice law, because being an MP, according to the wise wisdom of the Supreme Court, is not a full-time job, right? That is how, your Sibbals and your all of these guys, your Ravi Shankar Prasad and your Chidambaram and all of these guys are still, they could still practice law, right? Like for example, when BJP was not in power, Jaitley had a flourishing law practice. Now that Congress is not in power, Kapil Sibbal and his sons have a flourishing law practice. And it's a rare case that the sons of Kapil Sibbal, Amit Sibbal and Akhil Sibbal, and very importantly Akhil Sibbal, are extremely talented children, extremely talented. Like for example, we were discussing sedition, and I told you that a petition has been filed to challenge the constitutionality of sedition in the context of the Dharam Sansad and the hate speech issue that happened in Dharam Sansad in Haridwar and the Hindu Vahini in Delhi. It is Kapil Sibbal who's arguing that case. Okay, now, unfortunately, the fees that the lawyers charge is unregulated, which means that lawyers can literally charge anything under the sun, which is why some of my beloved colleagues in this profession make more money than the GDP of a small African country. Two, lawyers are exempt under GST. So which means like as a teacher, I have to pay my GST that the institutions give me, but as a lawyer, I don't have to. So that's the basic difference, right? So all of this is lawyer lobby, sort of doing their things. Third, FDI is not permitted at law firms in India, which means if there is a foreign law firm who wants to work with an Indian law firm, you can have a trust sort of a relationship, but you do not have what is called you can't invest directly in an Indian law firm. You can't buy equity of it. This is something which requires a lot of change. Also, lawyers like doctors have absolute restrictions on advertisements. Like in India, legal advertisements are not allowed. Like for example, you will never see this at the back of a scooty or a back of an auto that will say, want divorce now, call me. Want divorce how? Call me now. You won't see that anymore. You can't do that. The advertisement of legal professions is prohibited. If you have a website, the website can only have basic information about your contact details and a broad area of what you do, but it cannot be soliciting in nature. You cannot advertise, because India has a very traditional notion of law, that law is in the interest of justice and justice should not be advertised. Similarly, you can't have advertisements for doctors. You can have advertisements of hospitals, but not doctors, right? Dr. Batras is not a doctor. It's a hospital. It's a medical sort of a chain, right? So these are the things. Apart from this, what is also sort of interesting for you to know is that this entire setup is run in a very, very ad hoc manner, and of course there is the law. There's of course a lot of politics behind the law, but that's something that in the exam is not relevant for you. This is a broad system that you must understand. So now if somebody says they're a designated senior advocate, you know what this means. When somebody says that they're an advocate and record, this is what it means. Advocate is this, lawyer is this, and this is of course who's a jurist, right? We've understood these parts, we understood the broad areas of this. We now are sort of okay with how all of this sort of works. Nidhi has a very interesting question. Nidhi says, sir, what is the use of the wig, right? So the basic idea was, I'll explain this to you. The whole point of having a wig was that A, it will create uniformity, and two, when in parliaments used to raise points of orders and used to stand up and raise points of orders, which is an objection on violation of procedure, then you would hold your head like this. But when you hold your head, you'd be touching your head, so there was also a wig, right? Okay, so this is how it is. Uh, so this is the structure, this is the layout. I've sorry. Um, um, I've already covered the criminal justice system before you, where you understand who are prosecutors and who are public prosecutors and so on and so forth. But this is largely the structure and the layout of what is called the Indian judicial system. Okay, now we're clear with this, we're okay with this, we're fine with this. Okay, you can take about 5 minutes and take a note of this, and then we'll go to the basics of how they get appointed and all of those things. Then we'll of course do the mains part later, but we'll finish up layer 1 today itself. It's very easy. Oh, absolutely, Akash. Uh, actual volumes go into a lot of technical detail, go into several volumes such as HMCY and all of that. Yes, Varun. Okay. Sure. Attorney and lawyer mean the same thing. Attorney and lawyer means the same thing. A senior advocate is nothing but a lawyer who has been designated by the court. Uh, Not necessarily. Not necessarily. Court of record is that the court is bound to review its own judgments, and the court is also bound by its previous judgments. निखिल, there is no legal definition of a jurist. तो आप कह ही नहीं सकते कि jurist के लिए law degree होनी चाहिए. ठीक है. Okay, Yash. The advocate on record exam is not tough. Most people don't even need it. They can just hire an AOR to sign on a piece of paper. It's not a tough exam. It's an exam most people don't have the time to write because they're so busy with their practice. That's why. If you say or write anything which goes against the reputation of the court or a judge, it is criminal court of contempt. My law journey, Sahil, is irrelevant to your syllabus. As interesting as it might be, but it's irrelevant to your syllabus. How optimistic are you about our legal system? Senior advocates usually designated by high courts. Yes. Azim has a very good question actually. How optimistic are you about our legal system?
Uh, I mean, there are good times and there are bad times. Because Prakhar, the word Solicitor General and Attorney General of India have existed since older times, and even till today, it's the Attorney General who actually appears in court. If an Indian pursues a law degree from Britain, would we call a lawyer or a barrister? If you're practicing there, then you're a barrister. If you have a barrister's setup, then a license or a course, then yes, you're a barrister. In India, it doesn't make any difference if you're a barrister or not. Just because a topic is trending in current affairs, Ridesh, it doesn't make it relevant for the exam. Ashish, Solicitor Generals and Attorney Generals and Advocate Generals and Solicitor Generals and Attorney Generals, I'll cover when we do bodies. If it does not have a validity problem, then Abhishek, it's a valid certificate if it says it's valid for central government jobs. There is nothing called a chief legal officer. Yes, Amit, a lawyer can fight any case. Yes, Gopal, we've studied how contempt of court has an implication and is a reasonable restriction under Article 19, Clause 1, Clause A. All right. Now the rest of it is extremely easy. Don't worry about it. We'll first finish up the pre-part of it, then we'll go to the mains part of it. And the magic hopefully shall be executed again. Okay? Now let's look at appointments. And we're obviously concerned with Supreme Court and High Court because lower courts, we've understood it's a written exam which is conducted by the respective state government, can have compulsory state laws, and then of course interview panels are High Court judges of the specific state. So we're largely concerned with Supreme Court and High Court, right? So when we do look at Supreme Court, and then we will of course look at a High Court, and we'll do this comparatively. So the first thing first is you must understand is who is the appointing authority, the letter of appointment, because these are all appointed offices. So a letter of appointment has to be issued, an order has to be issued, right? An order has to be issued. Lokayukt and Lok Adalat we will do in bodies. Okay. Can you just wait for contempt of court, boss? I just explained broad concepts of it. I'll of course get into the details of it. Instead of worrying about what is being taught, we are worried about what will be taught. So just be a little patient. This is why, like for example, the kind of questions most people ask. Like there's somebody who's asking who can decide contempt of court. If you haven't read contempt of court, then you'll have to wait for me to explain it to you. If you've read contempt of court and you don't know who can decide, that means you've not read it properly. So in either of the two cases, you'll have to be patient for me to complete contempt of court. Okay. Like somebody's asking, PIL could be filed by whom? We've discussed public interest litigations as extensions to judicial activism, and we've covered this as similar arguments for PIL and judicial activism. I said anybody can, locus standi compromised. So you haven't read it properly. Anyway, so the authority for both is the President of India, and this is again an application of rule number 2, because the high courts are still the highest judicial organs of the state. Yet the president is the one who's issuing the appointment. Now, once we understand the authority, the issuing authority, we must then understand the strength of the Supreme Court and the High Courts. Now, as far as the strength is concerned, as far as Supreme Court strength is concerned, the Parliament, by a law, we've got a number of Supreme Court Judges Act kind of a thing, that law has to be changed. But as far as the strength of the High Court is concerned, it is actually done by the President. All of this, President is on the binding advice of the Council of Ministers. Okay, so don't think like the President is using their own heads. Very recently, we've changed the strength from 31 to 34, and this required it to be a financial bill, because you're adding new judges and there's going to be more money that you'll have to spend, therefore making it a financial bill, right? Now, each court has a leader. Now, if each court has a leader, then we have to understand who's the head and how is the head of the court usually appointed. So the head of the court here would be Chief Justice of India, and here would be the Chief Justice of the respective High Court, right? Respective High Court. Now, there is a procedure, and now there is a convention. So there is a procedure, and that procedure today, this procedure is defined in the Constitution, and additionally to the procedure, you have a convention. So the procedure for appointing the Chief Justice of India is that the President will consult the Supreme Court and High Court judges. Doesn't mention the number how many. It's just the President is supposed to consult Supreme Court and High Court judges. But the convention is, and this convention is not in the Constitution. The convention, which is a custom of sorts, especially the post-emergency era, you may recall. Post the emergency era, it's not in the Constitution. The senior most judge of the Supreme Court, is usually the one who is appointed as the Chief Justice of India. Okay. Now, what about Supreme Court, Chief Justice of High Court? Again, with respect to Chief Justice of High Court, you have to consult, the President will consult the Chief Justice of India and the Governor of the state, which again is rule number 2, as the Governor is appointed by the center and works as per central direction. But the convention is that this is a seniority principle. This is a seniority principle. Okay, a simple seniority principle. Now you would have a question. If this is a seniority principle, then how do you calculate seniority? So seniority is calculated in a simple format, which is number of years as a judge. In this, you will see number of years as a higher court judge or a lower court judge. Then number of years of practice as a lawyer, a number of years that you would have graduated out of law school or law college, and then of course your age. So this is the mechanism. Okay. Now, as far as your oath is concerned, this is also important because prelims may you get a lot of these questions. So as far as your oath is concerned, the oath to the Chief Justice of India, and any other Supreme Court judge is given by the President. So the oath to all Supreme Court judges is given by the President, and the oath to all High Court judges is given by the governor. This is of course because otherwise it will be a logistical nightmare. So you've got your oaths in place. Okay, you can take a minute and take a note of this. Then we'll start immediately after this. It's very simple. This is oath. कोई आर्टिकल करने की जरूरत नहीं है, बस इतना बहुत है प्री के लिए. आगे बढ़ते हैं भी. All right. Now, so this is authority of appointment. This is the strength. How do you appoint the head? And then, of course, you've got the oath. Right? Now, we move to the next. Supreme Court and High Courts. Now we're going to first understand what are your qualifications. Okay, very important. This is a lot of basic logic here. Qualifications. Firstly, there is no minimum age requirement. There is no minimum age requirement in either of the cases that you have to be minimum X number of years of age. That's not the case. So what are your qualifications? Your qualifications are, first, of course, you've got to be a citizen of India. Here also, citizen of India. For you to be a Supreme Court judge, you should have been a High Court judge for about 5 years, or you could have been a High Court judge for about 5 years, or you could have been a High Court lawyer, a lawyer practicing at the High Court for about 10 years. Okay, for about 10 years, or you could have been a distinguished jurist, which means somebody with immense knowledge of the law in the opinion of the president. In the mains analysis, we'll understand this through very interesting examples, and I have referred a lovely book. It was written many years ago, called by Aragya Sen Gupta and Ritvika Sharma. Lovely book called Appointment of Judges to the Supreme Court of India, which gives you, very interestingly how the judges are appointed. Are the judges really coming from the states? Are they really representing the states at the center? Do we have an equal number of representation or not? Right, is of course all of that for the High Court only, seniority principle, Nishant. Okay, so we'll come to that much later. We'll come to that when we come to the mains part, that how are states getting enough their people in the Supreme Court or not? What is there some problem with which lawyer, how lawyer? Is this more of a North Indian thing or not? We'll look at that. But for the pre, this is more than enough. Now, as far as your qualifications are concerned, here again the same. You've got to be a High Court lawyer for about 10 years, or you would have held any judicial office, a district court or anything, any judicial office for about 10 years. Okay, so these are your basic qualifications, but there's actually something very interesting. You will notice that the qualification, there is a common qualification. So the same qualification can make you a Supreme Court judge and a High Court judge. The same qualification. While Supreme Court judges are, of course, superior are higher judges. But if you just think about it, if you think about it carefully enough, the only thing special that the Supreme Court does is resolve center-state disputes. The only thing special that the Supreme Court does is resolve center-state disputes. And for center-state disputes, you have government lawyers. For center, you have attorney general, and for states, you have advocate general. They are the ones you argue on behalf of governments. So, the normal, ordinary lawyer will argue the same kind of case. Just think about it. If I take center-state jurisdiction away, then the Supreme Court and the High Court have more or less the same powers. You can go to both courts in case of fundamental rights are violated. You will eventually reach to both courts if legal rights are violated. You can question the validity of any law at both the courts. Civil cases, criminal cases, both can reach the Supreme Court, both can reach the High Court. They're more or less the same, right? They have almost the same powers. If I just take the center state away, if the work is more or less the same, then in that case, the qualification can also be the same. So if that is the case, then why was distinguished jurist not added here? Because the Supreme Court is the final interpreter of the Constitution. And sometimes you would require a very implied, a very academic understanding of Constituent Assembly debates. Say leading professors, leading legal jurists, legal educationalists who can give you an interpretation of the Constitution because that's their job to do. So sometimes when you make them as Supreme Court judges, it can help in better understanding the nuances of the Constitution. This, though, has never happened. We've never appointed a non-judge to a Supreme Court judge because you've got enough judges anyway. But that's largely how it is. Okay, so this is why it is. This is how it is, and this is what your qualifications are. Okay, now once we understand the qualifications, a very simple process. What is your age of retirement, and what is your what can you do post your retirement? Okay, so your retirement for Supreme Court is 65 years, and you cannot practice law. You cannot practice law as a lawyer. You cannot practice law as a lawyer anywhere in the country. Okay, and for High Court is 62, and you cannot practice law in whichever states you have been a High Court judge, because High Court judges can be transferred from state 1 to state 2. So in all the states that you have been a High Court judge, you cannot practice the law, right? Now you will see this number to be very constant, like for central and state bodies. That state bodies will usually retire at 62 and central bodies will usually retire at 65, so that they can be considered for a central or a national position. The 65-62 number is also very common for, say, Central Information Commission, State Information Commission, things like that. So anyways, so this is your basic retirement provision. Now, important. This does not mean that retired judges cannot be arbitrators, right? For example, Company A and Company B have decided that they will not go to a proper court, they will go to an arbitration, and they will basically get a retired Supreme Court or a High Court judge to be the chief arbitrator, and both sides can argue and try and finalize and solve their dispute. This is perfectly allowed. And what is also very interesting is there is no retirement age for lawyers, but there is certainly a retirement age for a judge. So it is okay for the lawyer to argue at 100 years of age. Like for example, Jethmalani used to argue till he was 1995. Fantastic lawyer, no doubt, but still, if you're arguing at 1995, that means that, of course, you are constrained by certain conditions. But if there are no age qualifications for lawyers, but there are certainly age qualifications for judges. Okay, very interesting. Now, this means that if you are going to be, there are going to be restrictions on retirement, we must also understand as clearly as possible what are your condition benefits. So you've got a salary and you've got a pension. Sorry, you've got a salary and you've got a pension, and here also you've got a salary and you've got a pension. Now, these judges perform an essential function of checks and balances. So maintaining their independence is crucial, maintaining their integrity is crucial. So the salaries and pensions of Supreme Court judges are charged expenditure to CFI. We've discussed this. Charged expenditure to CFI, or expenditure which is charged to CFI, which means you cannot reduce it to their disadvantage unless there is a financial emergency, which we will cover in the next set of lectures. As far as the salaries and pensions of High Court judges are concerned, as far as High Court salaries are concerned, these High Court salaries are charged to the consolidated fund of their respective states. Consolidated fund of their respective states. But the High Court pensions, these are charged to the consolidated fund of India. Why? Because you have nationally decided that High Court judges cannot practice in the states that there are. So it is the responsibility of the center to take care of their post-retirement well-being. So pension is charged to CFI, but salary of High Court judges is charged to the consolidated fund of the state. And in the state budget also, you can't reduce it to that disadvantage unless, of course, there is a financial constraint of some sort. Okay. So these are your financial benefits. Yes, High Court judges cannot practice law in the states that they've been High Court judges as a lawyer, and Supreme Court judges cannot practice law as a lawyer at any court in the country. Can they be arbitrators in an arbitration? Yes. Can they become chairpersons of bodies? Yes. Like for example, Justice Balakrishnan, I think. Yes. Not remembering the name correctly, was an ex-Chief Justice of India. After he retired, he became the chairperson of the National Human Rights Commission. Another ex-Chief Justice of India today is a sitting member of the Rajya Sabha. So, yeah. The only thing you can't do is you can't practice law as a lawyer. You can take a minute and just take a note of this, and then we'll continue with the rest. Okay. Now let's look at the details of the appointing procedure and the removals. Now let us look at the details of the appointing procedure or the appointment procedure. This is called collegium. Collegium is nothing but a group of judges. So let's understand this. For the Supreme Court, for the High Court. So how does this happen? Simple enough. There is a collegium of a total of 5 judges, wherein one is the Chief Justice of India and the other 4 are your other senior-most Supreme Court judges. Okay? All of them collectively agree on a name that this person should be made the Supreme Court judge. Okay? Collectively agree. Okay? And then this is sent to the president. Now the president can either say yes, or the president can say no, or can reject. On the advice of Council of Ministers, the president can sometimes send back the recommendation to the collegium and say, can you please work on it again and give us another name. They can choose to give another name, they can choose to give the same name. The law is not clear on what happens if they give the same name back. And of course, the current issue that has been going on is that there has been a delay in the government appointing judges on the basis of collegium that's related to your means. But this is more than enough. Isme first judge's case, second judge's case, third judge's case, plurality of judges, which basically means collectively agree on one name and give it to the president. बस इतना ही है. Means के लिए हम first judges, second judges, third judges, NJAC, इसमें क्या problems हैं, we'll cover that. But pre में इसके ऊपर कुछ नहीं आता. ठीक है? As far as the High Court judges are concerned, this collegium of 5 people becomes a collegium of 3 people, wherein you've got one who's the Chief Justice of India, okay, one who's the Chief Justice of India, and instead of 4 senior Supreme Court judges, you've got 2 senior Supreme Court judges, okay. They will collectively agree, same thing, on a single name, and the president, who's bound by the Council of Ministers, will take their advice, and also at the same time the president will also take the advice of the Chief Justice of the concerned High Court. कि आपको तो ठीक लग रहा है ना, आपके सीनियर चचा लोग ने हमको ये बताया है. And that is how this process is done. इसको complicate मत करिए, complicated है नहीं. The analysis is complicated, it is deeply complicated. ठीक है, but ये basic है, which also makes you understand that one of the largest democracies in the world, has a self-appointed judiciary. Okay, one of the largest democracies in the world has a self-appointed judiciary. इतना प्री के लिए बहुत है, इसके ऊपर पढ़ोगे एग्जाम के लिए रेलेवेंट नहीं है, मेंस के लिए है, वो भी मैं आपको थोड़ी देर में करा दूंगा. ठीक है, ऑल राइट. नाउ once we are understanding this, we now move to removals. थोड़ा सा टेक्निकल है, बट प्री के लिए बहुत सिंपल है, मेंस के लिए कॉम्प्लिकेटेड है. As far as removals is concerned, let's understand this. The process for Supreme Court and High Court removals is exactly the same, whether it is Chief Justice or any other judge, exact same process. for removals of any Supreme Court or a High Court judge. It's exactly the same. तो ये कैसे होता है? Of course, you've got your grounds which are mentioned in the Constitution. You also got some procedure which is mentioned in a special law called the Judges Inquiry Act, 1968, I think. Judges Inquiry Act. And then, of course, there is a majority procedure and the actual procedure. So as far as grounds are concerned, there are basically two grounds. First, proved misbehavior, and second is incapacity. Proved misbehavior और incapacity, ठीक है, इन दोनों ग्राउंड्स पे आप निकाल सकते हो. And to remove people, there will be a certain procedure that has to be followed. The procedure is, first, of course, an inquiry committee has to be formed. The composition of the committee is not relevant. That committee will get into the details of what happened, what were the issues. Yes, absolutely. The inquiry committee will get into what happened, what were the issues, why are we even going through this, where is the problem. And the inquiry committee, in fact, in India, plays an extremely underrated role as opposed to the role it is supposed to play, as opposed to the role that it is supposed to, sort of look at. It is, in fact, such a sad thing for India that not a single judge has ever been removed through the impeachment procedure. We've come very, very close. We've come extremely, extremely close, but we've never been able to successfully remove any judge on the basis of the procedure which is mentioned in these courts or in these laws. Right? Now, how does this work? It is very simple. So this Judges Inquiry Committee Act of 1968 will set up a committee, but before that, this procedure can be initiated either in the Lok Sabha or the Rajya Sabha. Both houses will always sit separately. The technical details are, you will have to first request the house. For that, about 100 members have to sign a motion saying that we want XYZ judge to be removed. Right now, it is usually 100 members for the Lok Sabha, and because the Rajya Sabha is half the strength of the Lok Sabha, so 50 members. Whichever house you're starting the impeachment procedure in. Okay, all right. Okay. Now, once this is done, the motion is admitted, and after the houses have said that, you know what, we want to do this, the final decision lies with the speaker or the chairperson. Even if 100 members of the Lok Sabha walk up to the presiding officer and say, nahi, humko nikalna hai, the final decision lies with the presiding officer of the house. Okay, and then what usually happens is, the speaker or the chairperson will constitute a 3-member committee. This 3-member committee will then be comprising of a judge of a chief justice or a judge of the Supreme Court, a chief justice of the High Court, and a distinguished jurist. So either CGI or a Supreme Court judge, the chief justice of any High Court, and a distinguished jurist. ओके, इन लोगों की कमेटी बिठाते हैं. प्री में कभी भी ये टेक्निकल डिटेल नहीं पूछेंगे, ठीक है. एंड देन वंस द कमेटी हैज सेड दैट नहीं बॉस, इसमें तो कुछ झोल है, वी रेकमेंड दैट दिस जज बी रिमूव्ड, देन यू विल रिक्वायर व्हाट इज कॉल्ड स्पेशल majority 2 in either of the houses, in both the houses, which is more than 2/3 of present at voting, in such a way that it is more than half of the total strength of the house. Okay. Now, the judge, while the proceedings are going on, can represent himself or herself, can have a lawyer represent, can address the house once permitted. Of course, it's a quasi-judicial process, so principles of natural justice will be taken into account. Okay, right? So, of course, this is how it is. Till date, we've never ever had a single judge ever removed, and it would be wrong to say that no judge has done anything particularly wrong. Okay, so that's that. Can the president reject return for collegium? Yes, of course. But what happens if it comes back? There's nothing really. I'll give you 2 minutes for this. I'll quickly revise this with you. Grounds are proved misbehavior and incapacity, exact same grounds for Supreme Court and High Court judges. A detailed procedure is laid down in the Judges Inquiry Act of 1968, in case the year is important to you. You will require a special majority too. How it starts is, it can start in either of the two houses. If it's the Lok Sabha, 100 members will send a motion to the Speaker of the Lok Sabha. If it's the Rajya Sabha, 50 members will send a motion notice to the Speaker, to the President of the Rajya Sabha, the Chairperson of the Rajya Sabha. After they are satisfied and the final decision lies with them, is when they will initiate proceedings from that specific house. A 3-member committee will be set up. After this 3-member committee gives their report that, you know what, yes, there is in fact a reason for impeachment, and then you will have special majority too. If the member committee says no, there is no reason, then doesn't matter. And even if they say no, then there will be no motion. But if they say yes, it does not necessarily mean the house has to agree with them. Okay. All right. Last part, extremely simple as far as the plea is concerned. The powers, or in fact, the jurisdiction. Okay. The powers, or let's say jurisdiction. Okay. Jurisdiction, as we know, is the capacity of the court to hear a matter. Now, broadly, there are 3 kinds of jurisdictions. As far as first is called original, which is you can file the case in the court. This is the first court that you can file a case in. Then there is something called appellate, that you're moving from a lower court to a higher court. And then you have advisory. Okay, advisory, wherein you're giving an advice to somebody. And lastly, you have something called writ jurisdiction, to basically enforce rights. ठीक है, तो फर्स्ट थिंग्स फर्स्ट, ये थोड़ा सा प्रोसीजरल है, इसलिए एग्जाम के लिए रेलेवेंट नहीं है. As far as the Supreme Court is concerned and original jurisdiction is concerned, that you can only and only go to the Supreme Court and nowhere else, is where there is a dispute between the center and state 1, or a dispute between state 1 versus state 2, or state 1, state 2 versus state 3, state 4. All of this is perfectly fine. A dispute between amongst the states, or a dispute between the center and the states, with the exception of interstate water disputes. And if it is a union territory without legislature, in that scenario, there is no dispute, because a union territory without legislature is under the center. And if it is a union territory with legislature, right, then depending on the issue, it can either go to the Supreme Court or the High Court, like the case of Delhi. Some cases went to the Supreme Court, some directly went to the High Court. So here, there is a little bit of complexity involved. This is extremely clear. This is your exception. Article 263, which we'll cover in center-state disputes, which talks about center-state sort of yes, Arzu. Center state relations, we'll cover that. Right? This is your Supreme Court jurisdiction. Okay. Now, as far as High Court jurisdiction is concerned, this is too technical again, but we'll give you some examples. Like, for example, if you have an issue with the outcome of an election, okay, if you have an issue with the outcome of an election, that, like, for example, in Indira Gandhi election case, that went to the Allahabad High Court. Indira Gandhi versus Raj Narayan, right? That went to the High Court. So, election petitions, which are primarily election outcome cases, okay, which are election outcome cases. Some cases where an FIR has to be quashed, that this FIR does not have any merit, so that can go to the High Court. The pre will never ask you this, the mains will never ask you this, because this is too diverse, too varied, and can change from state to state. This is something you should know. Now, appellate. Appellate means from a lower court you can go to a higher court. Again, there are two kinds of appellate provisions. One is general appellate and the second is special appellate, where we have something called special leave petition under 136 for the Supreme Court. General appellate is any civil case, any criminal case on appeal can go to the Supreme Court or the High Court. This is technical. Please don't do this. We have a lot of internal tests in place. There are a lot of procedural regularities. ये एग्जाम में नहीं आएगा. SLP आना चाहिए. SLP is basically a direct transfer of a case involving a substantial question of law, transfer of a case to the Supreme Court involving substantial question of law from any lower court in the country. Any lower court in the country. तुम ग्राम न्यायालय में हो, तुम सिविल कोर्ट में हो, तुम डिस्ट्रिक्ट कोर्ट में हो, तुम ट्राइब्यूनल में हो. If you are convinced that your case has a substantial question of law, requires an interpretation of law, then boss, take it to the Supreme Court directly. They will eventually have to hear the matter anyway. So let's not waste time. But this is not a guaranteed appeal. The Supreme Court has to first admit it. So first you have to convince your court that we need to go to the Supreme Court, and then you have to convince the Supreme Court to admit the petition. A lot of times I have noticed that SLPs get dismissed. Okay, बस इसके ऊपर एग्जाम में कोई नहीं पूछेगा, ये मेंस में नहीं पूछेंगे, ये आपको बस प्री में आना चाहिए कि SLP होता क्या है, because again this is technically very legal. Then you have advisory jurisdiction. Now, advisory jurisdiction does not exist for the high courts. It only exists for the Supreme Court. Only exists for the Supreme Court. And who are you advising? You are advising the president. अब दो तरह की एडवाइस होती है, एक कंपल्सरी एडवाइस और एक ऑप्शनल एडवाइस. नाउ इन केस नंबर 1, द सुप्रीम कोर्ट हैज टू render advice. They don't have an option. They have to render advice. We had mentioned this before. The second is the Supreme Court has the option not to. The Supreme Court has the option not to. Either you have to render advice or you have the option not to. Okay. Now let us say the Supreme Court has to render advice. In this scenario, this only happens where the issue is out of a pre-independence legal obligation कि 1935 में हमने किसी ट्रीटी को साइन करा था जो 2022 में इन्फोर्स करनी है. तो if the president asks you your legal opinion on this, then you have to. But if the president asks you a question on anything of national importance, any issue of public importance or national importance, ऐसा भी तो हो सकता है that the president on advice of the council of ministers is firing the gun from your shoulder. Let us say there is a lot of pressure on the government to say repeal farm laws, right? Let's assume the president can ask your opinion to the Supreme Court. Do you think farm laws should be repealed? Do you think EWS reservation must be streamlined. Do you think creamy layer must be applicable to SC ST? Do you think homosexuals should be given the right to marry? Now these are issues that the parliament must have the prerogative or the legislative prerogative over, but sometimes they fire the gun from the on the shoulder of the Supreme Court. सुप्रीम कोर्ट कहते हैं ऐसा नहीं चलेगा बस, मैं नहीं करने दूंगा, मैं नहीं बता रहा, जा कट्टी अपना देख, गलत करेगा मेरे पास केस आएगा, मैं स्ट्राइक डाउन कर दूंगा, लेकिन मैं पहले से नहीं बताऊंगा. ठीक है. एंड रिट्स वी ऑलरेडी स्टडीड सुप्रीम कोर्ट अंडर 32 डायरेक्ट एनफोर्समेंट ऑफ फंडामेंटल राइट्स एंड हाई कोर्ट्स अंडर 226 डायरेक्ट एनफोर्समेंट ऑफ फंडामेंटल एंड लीगल राइट्स. बस इसके ऊपर प्री में कुछ नहीं आएगा. इसको 10 बार रट लोगे तो कभी गलती नहीं होगी. आर्टिकल नंबर कभी नहीं पूछते तो आपको परेशान होने की जरूरत नहीं है. इन द मेन्स ऑफ कोर्स देयर इज आर्टिकल 141 143 कि उसमें सुओ मोटो इन द इंटरेस्ट ऑफ सुओ मोटो कुछ भी कर सकते हैं. वो कभी कभी ऑप्शंस में आ जाता है, बट डोंट वरी अबाउट इट, आपका भी क्लियर हो जाएगा. अरे जब जज ऑलरेडी हो तो कोलिजियम में नाम कहां से दोगे भाई? (262) is an exemption to 136. ESTP. With original jurisdiction can go to the Supreme Court and the High Court both, Papa. All right. चलिए. On an average, you will see 3 to 4 questions a year from this topic. There are, in fact, what is also very interesting to notice in the prelims, over the last years, we have seen almost on an alternative basis that questions have not been asked. लिखवा के ले लो, 2022 के prelims में जुडिशरी से सवाल आएगा. 2022 के प्रीलिम्स से जुडिशरी से सवाल आएगा. द पैटर्न विल नॉट गो रॉन्ग. ठीक है. दिस इज व्हाई अ प्रीवियस ईयर एनालिसिस इज इंपॉर्टेंट. अब देखिए, चलो, ये क्वेश्चन जुडिशरी का नहीं, फंडामेंटल राइट्स का है, करके बताओ। जुडिशियल कस्टडी मैंने आपको ऑलरेडी फंडामेंटल राइट्स में कराया है। जुडिशियल कस्टडी मीन्स accused is in the custody of the concerned magistrate and such accused is locked up in police station, not in jail. During judicial custody, the police officer in charge of the case is not allowed to interrogate the suspect without the approval of the court. Separation of powers, judicial custody is by the judiciary, so of course you will require permission of the judiciary to interrogate. Second option तो सही है। पहला, जुडिशियल कस्टडी लेन में उसमें नहीं होना चाहिए। इनफैक्ट अगर जुडिशियल कस्टडी ही है और पुलिस स्टेशन में रख रहे हो तो एग्जीक्यूटिव के छत्र छाया में रख रहे हो, वायलेटिंग सेपरेशन ऑफ पावर्स रूल नंबर 3। दैट इज वाई जुडिशियल कस्टडी हमेशा जेल में होती है, इन अ स्पेशल सेल। फर्स्ट इज रॉन्ग, बी इज करेक्ट। दिस इज योर आंसर 2021। ठीक है, करेक्ट। When the prisoner makes a sufficient case, parole cannot be denied to such a prisoner because it becomes a matter of his or her right. State governments have their own prisoners release on parole rules. पहली बात तो ये statement ही contradictory है that if they make a sufficient case, then the parole cannot be denied. Sufficiency is subjective. Sufficiency is subjective and therefore you cannot have a uniform law. So firstly that's what is called a contradiction. तो पहला ऑप्शन तो गलत ही है। अगर क्या सफिशिएंट है क्या नहीं है उसमें तुम गारंटी कैसे कर सकते हो? Just read it like an English comprehension. And state governments have their own prisoners release on parole rules. बताया था law and order is in the concurrent list. If it is in the concurrent list, then both the center and the states can have a law. So state governments don't necessarily have all of them. Second statement is also therefore now second statements, which means if it's in the concurrent list, which means the center and the states can both have it. In case the center does not have a law on it, then the states can have a law on it. चलो, याद नहीं आ रहा, खुद से सोचो, दोबारा सोचो। संजय दत्त का केस याद करो। संजय दत्त was sent on parole in Maharashtra. He was jailed in Maharashtra. इसमें कोई सेंटर का कोई रोल ही नहीं था। So second statement is correct. Okay. So second statement is correct. चलिए, ये जुडिशरी से रिलेटेड भी नहीं थे, ये फंडामेंटल राइट से रिलेटेड थे। अब ये बताओ, with reference to Indian judiciary, consider the following statements. Any retired judge of the Supreme Court can be called back to sit and act as a Supreme Court judge by the Chief Justice with the prior permission of the President of India. Judges कम पढ़ रहे हैं तो रिटायर्ड जज को बुला लो, एक्ट कर लेगा। वैसे भी प्रेसिडेंट अपॉइंट ही करता है and they have already qualified the collegium process before, which means that they are legitimately okay to become to become Supreme Court judges. Yes, these are called ad hoc judges. A high court in India has the power to review its own judgment as the Supreme Court does. मैंने बोला court of record होते हैं Supreme Court और high court. Both are correct options without the simplest problem. ठीक है? Yes, clear? Good. Consider the following statement. ये हमने थोड़ा सा पढ़ा था। The 44th Amendment of the Constitution to India, of the Constitution of India, this is the 1978 Amendment, introduced the article placing the election of the Prime Minister beyond judicial review. The Supreme Court of India struck down the 99th Amendment as being violative. अभी बताया था, this is about National Judicial Appointments Commission. दूसरा तो सही है, बट पहला क्या बताया था? नॉटी अमेंडमेंट 42nd, शॉर्टी अमेंडमेंट 44th, इलेक्शन खत्म हो चुका है। दिस अमेंडमेंट वी हैड स्पोकन अबाउट इन केस आनंदा भारती, द 39 कॉन्स्टिट्यूशनल अमेंडमेंट, which had put an immunity to the election of the prime minister. तो पहला गलत है, दूसरा सही है. The answer is B only. Correct, 2 only. ठीक है. With reference to the Constitution of India, consider the following statements. No High Court shall have the jurisdiction to declare any central law to be constitutionally invalid. An amendment to the Constitution cannot be questioned by the Supreme Court of India. पहले वाले में आने से पहले दूसरा तो 100% सही है, राइट? सॉरी यार, कहाँ पहुंच गए? सॉरी, दूसरा तो 100% सही है, करेक्ट. मतलब दूसरा 100% गलत है. अगर ऐसा होता तो पूरा केशवानंदा भारती का झंझट ही कहाँ से शुरू होता, राइट? सो ऑफ कोर्स द सेकंड ऑप्शन इज इनकरेक्ट. यहाँ पे क्या बोला है? नो हाई कोर्ट शैल हैव द जुरिस्डिक्शन टू डिक्लेयर एनी सेंट्रल लॉ टू बी कॉन्स्टिट्यूशनली इनवैलिड. मैंने क्लास में बहुत क्लियरली बताया था, इफ द हाई you can challenge any law that violates a fundamental right or a legal right at the High Court, and if it is a central law and the High Court strikes down the central law, it will not be valid. It will not be valid as in the domains of the state. ये हमने सेडिशन में भी देखा था, ये हमने होमोसेक्सुअलिटी के नास फाउंडेशन केस में भी देखा था. तो ये गलत है. Both the options are wrong. The answer should be D. ठीक है, अंडरस्टूड? यस. सिंपल क्वेश्चंस आते हैं, कोई मुश्किल क्वेश्चंस नहीं आते हैं इसमें. With reference to the Constitution of India, prohibition or limitations and provisions contained in ordinary laws cannot act as prohibitions or limitations on constitutional powers under 142. It could mean whatever. मैंने 142 आपको पढ़ाया नहीं है, तो आपको टेंशन नहीं लेना है. ये मीन्स के लिए है, बट तब भी मैंने नहीं पढ़ा है, आपको एग्जाम में याद नहीं आ रहा है. लुक एट द क्वेश्चन. विद रेफरेंस टू द कॉन्स्टिट्यूशन ऑफ इंडिया, prohibition or limitations or provisions contained in ordinary laws cannot act as prohibitions or limitations on the constitutional powers under 142. इतना तो पता है सुप्रीम कोर्ट से रिलेटेड कुछ है, करेक्ट? इस आर्टिकल नंबर की रेंज में. The decisions taken by election commission while discharging its duties cannot be challenged in the court of law. क्यों भाई? Since why election commission to be given judicially immune? Wrong option. In the B पे बाद में आते हैं. In the event of a grave financial crisis, the President of India can declare financial emergency without the consent of the cabinet. Democratic mandate आपने violate कर दिया, rule number 1. यहाँ आपने rule number 4 violate कर दिया, checks and balances. State legislatures cannot make laws on certain matters without the concurrence of the union legislature. The state legislatures cannot make laws on certain matters without the concurrence of the union legislature. क्यों भाई? Rule number 3, separation of powers. Center अपना law बनाएगा, state अपना law बनाएगा. The Supreme Court is not constrained by the exercise of its powers made by laws made by the parliament. This is nothing but suo moto. अगर मेरा मन करेगा तो मैं केस सुनेगा. ये सही है बिकॉज ऑफ रूल नंबर 4, चेक्स एंड बैलेंसेस. बिना आर्टिकल पढ़े, बिना आर्टिकल को जाने, बड़ा सिंपल तरीका होता है. ट्राई एंड सॉल्व द क्वेश्चन. आई सॉल्व दिस क्वेश्चन सिंपली ऑन रूल 1, 2, 3 एंड 4. मुझे जानने की जरूरत ही नहीं आर्टिकल 142 में क्या लिखा है. पढ़ के क्या कर लोगे? चलिए, गुड क्वेश्चन. द मोशन पहले तो देख लो भाई, क्या रिमूव कर सकते हैं ऑप्शन स्टेटमेंट्स में. इतना सीख जाना चाहिए. 1 and 2, 3 ओनली 3 and 4, 1, 3 and 4. अगर मैं 1 एलिमिनेट कर दूं तो 2 ऑप्शन हट जाएंगे. ठीक है. The motion to impeach a judge of the Supreme Court cannot be rejected by the Speaker of the Lok Sabha as per the judges. क्यों भाई? अभी तो बताया था. ऑफ कोर्स इट कैन बी रिजेक्टेड इफ इट्स अ malicious ग्राउंड. पहला ऑप्शन इनकरेक्ट है, तो पहला ऑप्शन इनकरेक्ट है, पहला ऑप्शन इनकरेक्ट है, तो मतलब ए और डी चला गया, राइट. ए और डी चला गया. अब मेरे को सिर्फ ये चेक करना है, मुझे सेकंड पढ़ने की जरूरत ही नहीं है. आई जस्ट हैव टू चेक वेदर 4 is also correct or not, because 3 is definitely correct. The details of the process of the impeachment is given in Judges Inquiry Act. करेक्ट. अब देखो सेकेंड और 3 कॉन्ट्राडिक्टरी है. द कॉन्स्टिट्यूशन ऑफ इंडिया डिफाइंस एंड गिव डिटेल्स एज व्हाट इज कॉल्ड प्रूव्ड एंड incapacity and proved misbehavior. यहाँ लिखा है डिटेल्स ऑफ द प्रोसेस ऑफ द इम्पीचमेंट आर गिवन इन द जजेस इंक्वायरी एक्ट. या तो ये सही होगा या तो ये सही होगा. द कॉन्स्टिट्यूशन नेवर डिफाइंस वेग टर्म्स. जब और कहीं नहीं डिफाइन करो तो ये कहाँ से करेंगे. सेकेंड ऑप्शन भी इनकरेक्ट है, मुझे पढ़ने की जरूरत नहीं थी. अब देखो, बिकॉज सेकेंड इज ऑलरेडी एलिमिनेटेड. If the motion of the impeachment of a judge is taken up for voting, the law requires the motion to be backed by each house of the parliament and supported by a majority of the total membership and not less than 2/3 of the members of present and voting. मतलब more than 2/3 in such a way it is more than half of the total strength. बिल्कुल सही बात कही. देखो इन्होंने कहीं लिखा स्पेशल majority for, नहीं लिखा, बिकॉज स्पेशल मेजॉरिटी 4 नाम की कोई चीज कॉन्स्टिट्यूशन में है ही नहीं. आपको इसलिए पूरा डिस्क्रिप्शन मिलेगा हमेशा. तो करेक्ट आंसर ऑफ कोर्स इज सी. ठीक है, नेक्स्ट. वाह वाह. Judicial review implies the power of the judiciary to pronounce upon the constitutionality of laws and executive orders, the power of the judiciary to question the wisdom of the laws. कल ही पढ़ा था wisdom. The power of the judiciary to review all legislative enactments before they are assented by the president. Separation of powers, rule number 3. The power of the judiciary to review its own judgments and given in earlier or similar cases. This is nothing but court of record. Power of the judiciary to question the wisdom would again be rule number 3, separation of powers. You can't do that. The power of the judiciary to pronounce upon the constitutionality of laws and executive orders. बिल्कुल सही, appropriate answer. 8A. 10 सेकेंड में बाउंड्री से छक्का मारते हुए, प्री के नंबर बटोरते हुए, बहुत सही. ठीक है, वेरी गुड. ऑल राइट. Who of the following is the custodian of the Constitution of India? Custodian मतलब कॉन्स्टिट्यूशन पे क्या अटैक करता है? लॉज दैट वायलेट द कॉन्स्टिट्यूशन. सो हु चेक्स द लॉज दैट वायलेट द कॉन्स्टिट्यूशन? सुप्रीम कोर्ट. टक 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 10 सेकेंड में आंसर निकला, आगे बढ़े. इट्स दैट सिंपल. ठीक है, अंडरस्टूड. इस पर तो समय बर्बाद ही नहीं करना है. द पावर टू इंक्रीज द नंबर ऑफ जजेस, अभी बताया. टक टक टक. पार्लियामेंट. सोचना ही नहीं है, मतलब पढ़ना ही नहीं है, क्या टाइम ही नहीं लगाना है. द पावर ऑफ द सुप्रीम कोर्ट टू डिसाइड डिस्प्यूट्स अंडर द सेंटर एंड द स्टेट्स. ओरिजिनल ज्यूरिसडिक्शन. मतलब मैं क्या ही कर रहा हूँ यार. चलो. टू ऑटोनॉमी ऑफ सुप्रीम कोर्ट ऑफ इंडिया व्हाइल अपॉइंटिंग. ये अच्छा क्वेश्चन है. व्हाट इज द प्रोविजन टू सेफगार्ड द ऑटोनॉमी? सबसे पहले देखिए एलिमिनेट क्या कर सकते हैं. एलिमिनेट अगर हमने 3 कर दिया तो हम निकल सकते हैं. लेट्स सी अगर ये चलता है कि नहीं, बिकॉज 3 हर जगह है, एक ही जगह 3 नहीं है. या 4, 3 या 4 में से अगर कुछ भी एलिमिनेट कर दो तो ओके. While appointing the Supreme Court judges, the President has to consult the Chief Justice of India. हाँ, ये तो सही है. The Supreme Court judges can be removed by the Chief Justice of India only. No, boss. Parliament checks and balances. The salaries of the judges are charged on the Consolidated Fund of India, on which the legislature does not have to vote. Yes, boss. ये तो सही है. All appointments of officers and staff to the Supreme Court are made by the government only after consulting only after consulting the Chief Justice of India. मतलब जो सुप्रीम कोर्ट का सिक्योरिटी होगा वो भी तो स्टाफ हुआ, जो पियोन होगा वो भी तो स्टाफ हुआ, उसके लिए भी चीफ जस्टिस को पूछेंगे नहीं ना. तो 4 एलिमिनेट कर दो. 4 एलिमिनेट कर दिया, क्या बचा? 1 and 3. बस देखो कीवर्ड्स ऑल. वेरी गुड. फिर एग्जैक्टली Which of the following are included in the jurisdiction of the Supreme Court? A dispute between government or one or more states. Yes. A dispute regarding elections to either house of the parliament. ये तो हाई कोर्ट में जाता है, बताया था. A dispute between government of India and a union territory. Assume करो without legislature है, तो maybe not. A dispute between two or more states. तो हमारे पास या तो 1 and 4 का ऑप्शन है, 1 and 3 का ऑप्शन ही नहीं है, तो बात ही खत्म हो गया. 1 and 4 खत्म, डन. 5 सेकेंड रूल, 5 सेकेंड. हाउ इज ऑप्शन सी करेक्ट? The salaries are charged for which legislature does not have to vote. Of course, because in the budget you have charged expenditure and you have demand for grants. Only demand for grants is voted. Charged expenditure is approved because you cannot reduce it to the disadvantage. ये हम कर चुके. All right. 14. The Supreme Court tenders advice to the President of India on its own initiative on a matter. अपने आप से उनको चुल है नहीं. तो जहां जब वन है हटा दो, या तो दूसरा सही है या तो तीसरा सही है. इफ ही सीक सच एन एडवाइस, यस, ओनली इफ द मैटर्स रिलेट टू फंडामेंटल राइट्स. नो बॉस ऑन जनरल इंपॉर्टेंस इफ द प्रेसिडेंट आस्क्स टू ओनली. बस ठीक है. तो चोमू टाइप क्वेश्चन है. ठीक है, ओके, अंडरस्टूड. क्या समझ में आया? क्या समझ में आया? थोड़ा पढ़ना है, अच्छा पढ़ना है. कहीं आर्टिकल नंबर दिखा? नहीं. कहीं टेक्निकल प्रोसीजर दिखा? नहीं. 2022 में जुडिशरी का क्वेश्चन आएगा? हाँ, इस टाइप का ही आएगा. लिख के ले लो. अंडरस्टूड दिस? यस और नो? यस और नो? Yes. Yes. We'll do the mains part of judiciary in the first half, then move to center state tomorrow. Day after तक center state खत्म कर देंगे, Wednesday तक. Then Thursday, Friday, Saturday, last class will be done. हाँ नया, हाँ absolutely नव्या, absolutely, absolutely. बिना पढ़ाई में क्वेश्चन, बिना टेस्ट करे मैं पढ़ाता नहीं हूं. यस, रूल्स, यूज 4 रूल्स. थ्योरी से ज्यादा जुडिशरी में करंट अफेयर्स होता ही नहीं है बॉस. देयर इज नथिंग प्री करंट अफेयर्स. यस. सी देखो, अब आप लोग ना, नाउ यू गाइज आर स्मूथली सेलिंग. अब तो टक 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 धीरे 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 मुश्किल काम हो गया है. जस्ट हैव टू अप्लाई द 4 रूल. ऐसा है तो ऐसा होगा, ऐसा है तो ऐसा होगा. प्रोसीजर 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 प्रोसीजर, कैरी ऑन, राइट.